Glad to have you on the program this evening. We're staying with developments in Abuja, where the Supreme Court has insisted that Nnamdi Kanu must face trial. You can join the conversation right now on X, formerly Twitter, using the hashtag Beyond 100 Days. Remember to tag at TVC News NG and at Nifemi Okuntoye. So the court upheld the federal government's appeal challenging the verdict of the appeal court, which dismissed the charges against Nnamdi Kanu. The Supreme Court held that Mr. Kanu must face trial. Delivering judgment prepared by Justice Garba Lawal, Justice Emmanuel Agim held that the Court of Appeal was wrong to hold that Kanu couldn't be tried again based on the illegality perpetrated against him by the federal government following the invasion of his home. The Apex Court subsequently allowed the appeal of the federal government, dismissing the cross-appeal filed by Mr. Kanu.
It was not a good day for Nnamdi Kanu's family and friends, as they had hoped that the Supreme Court would align itself with the judgment of the Court of Appeal. The Supreme Court swayed in another direction to say, although due process of criminal law was not followed, the federal government was in violation of Kenya Extradition Act and Nigerian Extradition Act. It does not render the trial an illegality. There is no clear provision of the law in Nigeria that says a trial court can no longer have jurisdiction where the prosecution does anything illegal against an accused person. Justice Emmanuel Agim, who read the lead judgment, held that the violation of Mr. Kanu's right ought to have been filed by way of civil procedure. The lower court remained in the realms of sentiments in the case. Justice Agim asks if law enforcement means to do anything to enforce the law. He answers in the negative, as it does not mean to commit a crime to enforce the law. He says the court cannot uphold the judgment of the Court of Appeal.
Knows better. The Supreme Court is the Supreme Court. What the Supreme Court says represents the law. We respect it. We go by it. There is no other way. We had hoped that it would come our way, but it has gone the other way.
Came very heavy on the security agencies, where they have in any way, impaired on the rights, the fundamental rights of the defendant. However, our laws have made very clear provision for remedy. Where there's such infraction on the right of the defendant, then you can have, such a defendant can go to the civil court.
Mr. Kanu has been in detention since June 2021 when he was rearrested in Kenya after the federal government was alleged to have forcefully extradited him to Nigeria. He was arraigned before the Federal High Court in Abuja on a 4-count charge of treasonable felony, conspiracy to commit treasonable felony, terrorism, illegal importation of radio equipment, and defamation of former President Muhammadu Buhari. The charges were later amended to a 15-count charge on terrorism and membership of a proscribed group. Justice Binta Nyanku of the trial court had in her ruling dismissed 8 out of the 15-count charges, saying that Mr. Kanu has questions to answer in the remaining 7 charges. Dissatisfied with the ruling, Mr. Kanu appealed to the Court of Appeal. The Court of Appeal had dismissed the remaining charges and ordered that Mr. Kanu should be released. The court, however, granted a stay of execution of its judgment after the federal government had appealed to the Supreme Court. Mr. Kanu then appealed to the Supreme Court challenging the stay of execution granted by the Court of Appeal, which halted his release, and the federal government appealed challenging the judgment of the appellate court dismissing the remaining charges.
Riding on this extract from the ruling of the Supreme Court today, Kanu, as the father of the nation, issue a broadcast and then issue knowledge, discontinue the trial and grant him unconditional bail and commence the process for political and political solutions to the matter. So that at the end of the day, every part of Nigeria can come together on that principle of justice, equity, and fairness.
Although the Supreme Court sympathized with Mr. Kanu on how he was extraordinarily renditioned to Nigeria, the court says the law must remain the law. With this judgment, Mr. Kanu will have to go back to the Federal High Court Abuja and appear before Justice Binta Nyanku to answer to the remaining 7-count charges against him. Celestina Iria, TVC News, Abuja.
Let's get some more understanding about what happened in court today. Celestina joins me live from our Abuja studio. Celestina, let's begin from October last year. The Court of Appeal decision that dismissed the charges against Mr. Kanu, we believe, was based on what was called the illegality of the extraordinary rendition of Mr. Kanu from Kenya to Nigeria. That was in 2021. What is the position of the Supreme Court on this?
Okay, well, Nifemi, the Supreme Court said that, yes, they agree with Mr. Kanu that the federal government did committed an offense by the way they extraordinarily renditioned him to the country. We know extradition, we have an extradition act in the country, and also where he was extradited from in Kenya, Kenya also has an extradition act. These acts were not followed. No extradition procedure was initiated at the Federal High Court. Usually, if Nigeria wants to extradite any person, they send an extradition request to the country where the person is alleged to be. Every country has their own laws. So we don't know how Kenya conducts their own extradition procedure. But for Nigeria, if Nigeria receives an extradition request, the federal government cannot grant it. They will have to still go to the court to seek the order from the court. The court will now grant the permission to say, okay, you have the right to take this person out of this country to the country where he or she is being alleged to have committed an offense to go and be tried. But none of such procedures was conducted or followed. But the court now said that irrespective of the violation of these acts, the trial shouldn't have been stopped. The Court of Appeal, the court said that were in sentiments because they ought not to have dismissed the remaining 7 count charges. They said they did not, the Supreme Court said that yes, they do not blame nnamdi Kanu for fleeing the country in 2015 where his hometown and his house was invaded. But still, they cannot do anything because the law is the law. He has to go back to the Federal High Court before Justice Binta Yanku and answer to the remaining 7 count charge. The Supreme Court also said that his bail ought not to have been revoked, that he should have been granted bail. He should have been taken away from the DSS facility. But we had expected, and also maybe because the judgment from the trial court was halfway, because it was like 50-50 for nnamdi Kanu has been cancelled, because the court struck out 8, leaving 7. And the Court of Appeal gave them a relief because the Court of Appeal dismissed it in its entirety. But the Supreme Court said that there is no law backing the action of the Court of Appeal as Nigeria stands today. If the security agency commits or in violation of the law or violates the rights of any citizen in the process of carrying out their duty, if the person is arrested and stands to be tried, that violation by the security agency cannot stop the trial from going on. What the victim can do is go to the Federal High Court or any appropriate court, file a fundamental rights enforcement suit to get justice. But whatever that person has been accused of or is accused of, the person would have to answer for it.
Interesting to hear the Supreme Court say that there is no Nigerian law that prohibits the use of illegally obtained evidence for the trial of a defendant. But this case, Celestina, started as far back as 2015 and had been put on hold at the Federal High Court in Abuja after the Court of Appeal dismissed the charges in what is now known as the October 2022 judgment. But is there hope of an expedited court hearing in this regard? Is that something that was mentioned at all at the Apex Court?
Well, the court did not expressly say anything about expediting the hearing at the trial court, but the Federal High Court will be going on holidays from on the 18th. So whatever needs to be done will be done in January. So we don't know when Justice hearing notice or for continuation of trial, the notice will be issued out to nnamdi Kanu and his counsel. But we believe that the first course or the first line of action for his lawyers will be to apply for his bail since he has been in detention in 2021. And talking about the obtaining of evidences, this is also a cause of concern because we recall that the ACJA now says that if a defendant comes to court and say that a statement or a confessional statement was gotten from me by the security agency or the IPO through torture, the court will conduct what we call trial within trial. And usually before now, if the court finds that yes, indeed, it was obtained through torture, thereby violating the rights of that suspect or defendant, the court will discard that evidence. And nothing will be done to the alleged offender, which is maybe the investigating officer, as the case may be. But now there's a difference to that. When a trial within trial is conducted and the court found out that yes, torture was involved, violation of rights were involved in the process, the court disregards the evidence, and also the person, the offender who committed a particular offense, will be punished. So, but now the question that we journalists posed to the council representing the federal government was, would this not make the security agencies become brazen to carry out extradition the way they like and feel, oh, we can do it an illegal way, then come to the court? What the defendants would do is just to file a fundamental rights enforcement suit. By and large, we've gotten what we want to get by bringing the person back to the country, either way. But he said no, the court took a swipe at the security agencies. Yes, indeed, the court took a swipe at the security agencies. But would this deter them from going the wrong routes so that next time they follow through the right procedure? So this is something that we would hope to see in the future, that they make amends.
Interesting development. It took well over a year before the Supreme Court judgment on this matter. Some have suggested a political solution outside court that was rebuffed by the previous administration. We'll see how all of this play out in the coming days. Judiciary correspondent Celestina Ira live for us in our Abuja studio. Good to see you, Celestina.